नमस्ते फ्रेंड, आप सभी का एक बार फिर से वेलकम और उम्मीद करते हैं कि आप सभी लोग अच्छी तरह से होंगे। फ्रेंड्स, सुप्रीम कोर्ट ने एक सुप्रीम कोर्ट ने सेंट्रल बैंक के एक्स एम्प्लाई श्री विजय कुमार को रिलीफ प्रोवाइड किया एक जजमेंट के माध्यम से। पेंशन ए कॉन्स्टिट्यूशनल राइट कैन नॉट बी रिड्यूस्ड विदाउट प्रॉपर प्रोसीजर। सुप्रीम कोर्ट श्री विजय कुमार सेंट्रल बैंक के एक्स एम्प्लाई हैं, जिनको पेंशन रिड्यूस करने के बारे बैंक ने डिसीजन लिया था। उस संबंध में सुप्रीम कोर्ट ने एक रूलिंग दी है, अपना जजमेंट दिया है। केस टाइटल है श्री विजय कुमार वर्सेस सेंट्रल बैंक ऑफ इंडिया। द सुप्रीम कोर्ट प्रोवाइडेड रिलीफ टू एक्स सेंट्रल बैंक ऑफ इंडिया एम्प्लॉय whose pension was reduced by 1/3 without consulting board of directors as mandated under Central Bank Employees Pension Regulation 95. The court reiterated that pension is an employee's right to property, which is a constitutional right that cannot be denied without the authority of law, even if an employee was compulsorily retired on account of misconduct. When Regulation 33 of the bank specifically mentioned that no reduction in the pension would be made without prior consultation with the board of directors, then the act of bank to reduce the appellant's pension by 1/3 was arbitrary and unjustified, the court said. There is no cavil that pension is not a discretion of the employer but a valuable right to property and can be denied only through authority of law. When an authority is vested with the discretion to grant pension less than full pension admissible under the pension regulations, all procedural safeguards in favor of the employees, including prior consultation, must be strictly followed. The court observed, a plain reading of Regulation 33 would show award of pension less than full pension is to be done with the prior consultation of the board of directors. Such prior consultation with the highest authority of the bank, that is board of directors, must be understood as a valuable mandatory safeguard before an employee's constitutional right to pension is curtailed. In these circumstances, a post facto approval cannot be substitute of prior consultation with the board before the decision is made, the court added. The bench, comprising Justice P.S. Narasimha and the Jomalaya Bagchi, heard the case involving an appellant who was found guilty of sanctioning 12 housing and mortgage loans in breach of procedural norms, exposing the bank to a potential loss of rupees 3.26 crore. ऐसे हाउसिंग लोन क्या था, केस था जिसके से बैंक को लॉस हुआ था 3.26 करोड़ का। ए डिपार्टमेंटल इंक्वायरी इनिशिएटेड अंडर रेगुलेशन 23 of the Central Bank of India Officers Employee Service Regulations continued even after his retirement. He was compulsorily retired with the effect from his superannuation date, that is the 30 November 2014. Subsequently, the bank, through the appellate authority, ordered a reduction of his pension by 1/3 without consulting the board of directors. The Patna High Court upheld this action, prompting the appellant to approach the Supreme Court. Setting aside the High Court decision, the judgment authored by Justice Bagchi interpreting Clause 1 and 2 of the Regulation 33 observed that although a higher authority is vested with the power to grant pension not less than the 2/3 of full pension under Clause 1, but if any competent authority, disciplinary appellate or reviewing intends to award less than full pension, it must first consult the board of directors as stated under the Clause 2. Accordingly, the appeal was allowed and the High Court's order and the bank's pension reduction order were set aside. The court directed the bank to reconsider the matter within 2 months after giving the appellant an opportunity of hearing and obtaining prior approval from the board of directors. केस टाइटल है विजय कुमार वर्सेस सेंट्रल बैंक ऑफ इंडिया। और कहीं कहीं पे जब कोर्ट का डिसीजन अच्छा भी आता है, लेकिन कोर्ट किस क्लास का इंटरप्रिटेशन कैसे करती है ये कोर्ट ही जानती है। थैंक यू, नमस्ते।